FASLI. Tell me the FASLI. Get me in.
Are you okay if I really miss something? You're okay for...
These are
Hello, this is a quick sound test. Hello? Hello and welcome to the ASLI live stream. Tonight's topic is the ASLI Legal Interpreting Best Practices Guidelines. The talk, just wait while we sort out the studio lighting. The talk is being given by Kal Newby. My name's Robert Skinner. I'm one of the directors of ASLI. Interpreting. So you should see the lovely Danny Stubbs interpreting on screen. So I'd first like to thank Karen Newby for agreeing to give us tonight's talk, and also thank you to Danny for volunteering interpreting tonight. It's a challenging topic, so we'll keep him on his toes. Before I hand over to Cal, I'd like to also thank everyone joining us today, and those of you who joined us for the video interpreting best practice with Helen Ryan. We received a lot of feedback, mainly to do with the technical setup, some sound and video issues. We're trying this again. It's work in progress. So please do send us your feedback of your experience tonight. We are looking at ways of sharing knowledge, sharing skills to as many interpreters as possible, so that we can make the interpreter a better place. And so I'm sure you appreciate that. So without further ado, I'm going to hand over to Karen Newby, but you don't want to just hear a voice, so it's important that we get to see her too. So Karen, would you like to poke your head into the camera?
Hope everyone's enjoying this evening and will enjoy this presentation. I'm just going to get myself comfortable with all my various bits of kit that I'm referring to. So just bear with me 1 second. Do use the text instant messaging facility within the software. So we will let us know if there are any problems using software. Rob is on hand to try and resolve them if possible. And do post your questions. We'll have a question section at the end of the presentation. Okay, so first, I'm just attempting to move my first slide and it's not working, so just bear with me a second. There we go. So this presentation this evening will cover the following. Firstly, I'll talk a little bit about the history of the legal interpreting best practices. I'll then move on to cover some of the content, which obviously there's no time to go into it in great detail, but I'll cover the most general pertinent sections. We'll then mention the way it's being used currently, and then there'll be time for you to ask your questions. So the history. I guess this was initiated during a trial that I was involved with in May 2014, which was a criminal trial involving multiple deaf parties. There were lots of discussions between the various interpreters and members of the police and legal services during that trial about how best interpreting services were being used and how best the deaf population were accessing that trial. The Metropolitan Police subsequently held a post-trial review and actually interviewed a number of deaf people who had been involved and a number of interpreters who had been involved in that trial to see whether any lessons could have been learned or could be learned to take forward into the future and improve on practices. As a result of that, I was invited to deliver a workshop at the Metropolitan Police Training College in Hendon during their specialist interview advisory course. So I took a session for 2 or 3 hours called Interviews with Deaf People, where I gave some advice based on my own experience and based on talking to other interpreters about how the police can most effectively go about conducting interviews with deaf people. It was there that I met Jason Weald, who was at the time a lead interview advisor with the Met. And it was kind of a result of my discussions with Jason that led me to doing quite a big search of whether there were any guidelines in place in other countries with regards to the police and court system conducting interviews and dealing with deaf people that they come into contact with. I came across a set of guidelines in the USA which I thought were very thorough, and I got into contact with the National Consortium of Interpreter Education Centres over in the USA, and I sought permission to modify their best practices for use within the English and Welsh legal system. And that permission was granted. So it was at that time, which I think was probably late 2014, maybe early 2015, that I began, along with Jason, editing those guidelines with regards to BSL interpreting profession and with regards to the legal system in place over here. So the guidelines themselves, hopefully you've had a look at them. If you haven't had the opportunity to do that yet, you can perhaps do so while we're online, or you can do so after the workshop. The structure of them is as follows. They begin with an introduction, which covers such thing. Well, our set of guidelines covers an introduction to ASLI and what ASLI is all about. There's then some background of the guidelines and some acknowledgements. There's a description then of the purpose of having a set of best practices. There's then an overview of the best practices within the document, and then the document moves on to cover the 9 primary best practices that we'll focus on this evening. At the back, there's a definition of terms, followed by a set of references and some appendices. I'll just check my notes to make sure I've covered everything. So moving on to the main thrust of the document, there are 9 primary sections included, and they are as follows. The first one deals with effective interpretation in the legal system. Next, it moves on to team interpreting. It then covers collaborating with deaf interpreters, the visual recording of statements and interpretations, training and experience of interpreters, the recruitment of interpreting practitioners within the legal system, preparation, lawyer-client interactions, and then finally law enforcement interactions. And just to mention, we're using the term law enforcement specifically because it's quite a generic term, because when it comes to the legal system as a whole, there's a number of different professionals who are tasked with law enforcement. So, for example, obviously, the first one we all think about is the police, but we also have DWP investigation officers, immigration officers, a number of different representatives who can conduct such things as interviews to gain evidence for legal services. So, Section A of the document looks at effectiveness. This covers some obvious things, such as the fact that interpreters should possess the knowledge, skills, and ability to provide a meaningful and effective interpretation, and it impresses upon readers the importance of accuracy in these high-risk settings. One of the main points made is that accuracy requires time, and the document then moves on to discuss the idea of consecutive interpreting being used to deal with complex utterances. And the document really impresses upon us the importance of consideration being given to consecutive interpreting, because, and actually this comes from research that was conducted by Deborah Russell, who's currently FASLI president, based in Canada. And research suggests that for complex utterances, consecutive interpreting is the best approach. However, as we all know, traditionally, sign language interpreters have sort of by default aimed at the use of simultaneous interpreting as being our sort of generic best practice. And what this document does is emphasize the fact that that's certainly not always the best option when we're dealing with high risk interactions and complex utterances. So it then moves on to sort of planting the seed of note-taking as a tool that then should come into play, because obviously if we are working consecutively and if the utterances are complex, then we're at risk of our short-term memory not serving us. And therefore it's suggested that sign language interpreters need to be looking at note-taking much more than we currently do as a tool to assist with our interpretations in these kind of settings. Deborah's more recent research actually suggests a blended approach, and this is that she's looked at interpreters actually switching during discourse between simultaneous and consecutive interpreting, depending on what best suits the demands of the current discourse. Often interpreters in legal settings will do this quite intuitively, where they'll fairly quickly identify that an utterance in the source language is of a complex nature, and they will wait for the end of that utterance before they begin to render their interpretation. However, not all interpreters in these kind of settings are making use of that approach. We often we tend to find it when, for example, a barrister poses a question to a deaf person who's taken the witness stand, where interpreters fairly commonly will wait for the end of the question before they render that interpretation. However, when the response comes back from the deaf person testifying, quite often the interpreters will sort of default into a more simultaneous mode, and the document sort of tries to place it into our consciousness that that's not always the best approach, and that we should actually question our strategies, whether we be dealing with spoken or signed language. It also covers a number of factors that affect the quality of simultaneous interpreting. I'm just going to read out a section that refers to that. So in section 4.2, it covers factors affecting the accuracy of simultaneous interpretation. And whilst acknowledging that simultaneous interpretation can be meaningful and effective, particularly if interpreting for a deaf person who's fluent in English. So if we're using a more sign-supported English approach, then SIM can certainly be very effective in that case. But there are circumstances where SIM may not be the best approach, and it's important to bear those circumstances in mind. So, for example, the interpreter's familiarity with the subject matter, the predictability of communication, the amount of prior preparation, the speed at which the interpreter is expected to keep pace, their mental and physical fatigue, and specific needs of the deaf party, among other things. Okay. So moving on to section B, which covers teamwork. Obviously, we know that team working is a quality control mechanism, and research has found that mental fatigue comes into play after about 30 minutes, regardless of the experience and skill of the interpreter, and that most often interpreters seem fairly unaware of the decline in the quality of their interpretation, which is why it's really important to have other members of the team monitoring our output. And other research has found that at least 22 cognitive skills are being employed when we are interpreting. So it's, as we all know, it's a fairly challenging job to do. And I'll just read a quote out from some research conducted by Vidal, which is that fatigue for interpreters is not primarily physical, as in the case of athletes whose muscles become strained after sustained exertion. It is mental fatigue, resulting from complex mental processing and the high degree of concentration the interpreter must have to hear, then understand, analyse, and finally express ideas coherently in another language. Section C deals with deaf interpreters. And within the document, you'll see that deaf people with certain characteristics are suggested as being identified as those who could benefit from deaf interpreters joining a team with hearing interpreters in a legal setting. Those characteristics listed in the document are as follows: someone with underdeveloped sign language skills, someone who has had limited socialisation within the deaf community, someone with a limited education, someone who experiences cognitive challenges, who has delayed language, who has organic issues causing affect deficiencies, someone with mental illness, someone with problems caused by drug abuse, and someone with other physical challenges. And just to add to that, I believe that that means specifically physical challenges that will affect their use of language. The guidelines point out that if a deaf interpreter has been engaged, then they should actually be present for all interactions with that deaf person. So not simply to work within the courtroom, for example. They need to be there needs to also be a deaf interpreter working outside of court, so that the deaf person requiring the services of a deaf interpreter will be able to access communication and give instruction to their counsel, as well as being able to access the courtroom interactions. It also suggests that separate teams of deaf interpreters, just as we have with hearing interpreters, should be engaged for the different roles of the courtroom. So you'll see on the slide there's abbreviations PI and TI, and this refers to proceeding interpreters, who we often call court interpreters, and table interpreters, also known as counsel interpreters, and in criminal trials we often refer to them as defence interpreters. So if separate teams of hearing interpreters are required to carry out the court interpreting role, then and the counsel interpreting role, then likewise should be separate teams of deaf interpreters. And also the document stresses that in the cases of children and young people, it's almost always the case that a deaf interpreter will assist in communication. Section D covers video recording. As I'm sure you all know, the only way to preserve a statement made in BSL is to record it visually. And it's also the only way to preserve an interpretation that works into BSL as one of its languages. It's really important that sound must be simultaneously recorded along with the visual recording. And sometimes this necessitates additional cameras. So I'm sure some of you have experienced attending a police station where the cameras in the interview room are not adequate to capture both the deaf person and the interpreter. And in such cases, it is appropriate to ask the police officers or the investigating officers to supply another camera so that both parties can be captured. Often officers will tell you it's not possible, and it certainly might not be immediately possible, but it certainly is not impossible. Personally, I've had an experience where an interview was conducted in hospital because a victim of a physical attack was still being treated medically, and the police officers attended the hospital with equipment that enabled both the deaf witness / victim and the interpreter, so a separate video camera for each, and audio recording equipment too. So query things if you're told that certain things aren't possible. On the next slide, you will see a picture, which is one of the most modern interview rooms that I've encountered, with the most modern digital recording equipment. In this picture, in the centre of the screen, you'll see a deaf man who was being interviewed as a suspect of a crime. In the top right-hand corner, you'll see the fisheye view, which is required to capture the entire room so that every party that's present in the room is on camera. At the top left-hand side of the screen, you'll see the interpreter in a box. And this is one of the best examples that I've personally seen, where both the interpreter and deaf individual are captured with enough clarity that an assessment of the interpretation could be conducted quite successfully after the event. Section E of the document considers the training of interpreters, and suggests that all interpreters should have received some specialist training. And certainly I know BSL interpreters in the UK who have done such things as undertaken law degrees or other levels of legal training beyond just becoming a generalist interpreter. There's no specialist BSL interpreting certification currently in the UK. However, Article 2 of the European Directive on the right to interpretation and translation in criminal proceedings does stipulate the right to access an interpreter who shall be of quality sufficient to safeguard the fairness of the proceedings. And so I would suggest that although there is no current specialist certification for BSL interpreters in the UK, it's certainly advisable, if at all possible, to go on and acquire some additional legal knowledge beyond your general interpreting training. And the last point on that slide is that domain-specific mentoring and supervision is vital, and I would agree that if you wish to become a successful legal interpreter, then it's really important to find yourself a mentor or a supervisor who is themselves a very experienced and competent legal interpreter who can guide you through that process. Section F looks at the recruitment of practitioners for legal interpreting. So, as I'm sure many of you know, there are multiple interpreters required during a case for a number of different roles, and this is specifically to avoid any conflicts and to preserve the integrity of the interpretation. So we have, as already mentioned, the proceedings interpreters, so those interpreters who work for the court and only in the court during a case. We also have the counsel or table interpreters, so in a criminal case, we would often term that as defence interpreter, and so these are those interpreters who work outside of the court with the deaf party so that they can give instruction to and access advice from their counsel. Those interpreters are also expected to observe the court proceedings and alert counsel to any issues with regards to the proceedings interpreters. And we also need to consider diversity of deaf parties. If there are multiple deaf parties within the legal proceeding, such as a deaf defendant and a deaf witness, they may have quite differing use of language, and therefore separate interpreting teams need to be considered so that the language needs of all deaf parties can be appropriately supplied. Also such things as special measures. So this is circumstance where, for example, a deaf witness may not want to come into contact with the defendant in court, and such things as screens may be erected around the witness stand, or a video link from another room or from another court can be established, and therefore separate teams of interpreters will be required to work to that witness and another team to the defendant, so that both parties are able to see language with clarity. And the same kind of considerations need to be paid to deaf interpreters being brought in, and also whether an intermediary has been involved within the case, either at the police stage or the investigation stage, and whether that intermediary has actually produced a report to the court with regards to the deaf party's communication requirements. It'd be really important for an interpreting team to have sight of that report so that they can properly consider what the needs and requirements will be during the case. Section F also considers rehearsal and appearance conflicts. So this would be, with regards to rehearsal, a scenario where it's to be avoided that an interpreter who's interpreted at police interview stage or investigation interview stage is also an interpreter who is engaged for the court at a later stage, because obviously they will potentially remember information that's been presented at investigation stage, which could taint their interpretation within the court. The appearance conflict would include such things as an interpreter being related to a deaf party, or an interpreter being known to a deaf party for other reasons. So the fact that they may have come into contact with them during other times, other parts of their career, or other times in the deaf person's life. There was quite a well-reported example of this, not for England and Wales, but in Scotland a year or so ago, where an interpreter was had been working with a deaf party for a number of years, and was then engaged to interpret between that deaf person at a police interview. And they subsequently then also became the interpreter who interpreted during court proceedings. And the reason being that this deaf person had sort of non-standard use of BSL, and there were very few interpreters capable of effectively working with that person. As I understand it, the interpreter was very open with the fact that they had such prior knowledge of the deaf person and had been involved in other stages of the investigation. And the judge at the trial agreed that that interpreter should continue. However, the conviction was later appealed, and the primary reason for the appeal was the lack of impartiality of the interpreter that was engaged at trial, and the appeal was in fact upheld. So we certainly need to be mindful of those situations. Also, just the last point there, we need to be very mindful of consistency and continuity. So avoiding changing members of the interpreting team midway through a trial or midway through witness testimony. I think our interpreters are going to swap over momentarily, so I'll just pause there. Right. Section G of the best practices looks at preparation, suggesting that the interpreting team, specifically proceedings interpreters, should have sight of case files and documentation before embarking on a trial. This is often contentious. I'm sure, so I certainly have come up against resistance in cases where I have asked to see files prior to a trial beginning. However, the document is best practices, and so we're talking sort of ideal world scenarios here. I guess what I can say is all we can do is try, and we are at the mercy of the court often when it comes to having sight of those ahead of time. Researching relevant information, the opportunity of knowing what some elements of the trial are going to be prior to them, prior to you facing them, will give you the opportunity to research up front. And I'm thinking particularly in cases where the expression of medical procedures or physical injuries is taking place. So, for example, a brain injury might be discussed by an expert witness, and they might go to very great detail physiologically, and it will really serve the interpreting team if they have been able to research that ahead of time so that they can most effectively render those elements into the target visual language. Ideally, the interpreting team should meet with the judge and with counsel prior to embarking on the trial. Often judges and counsels have not been involved with cases involving deaf parties previously, and they will not have thought of a number of different things that we just automatically know to consider. And so it's always useful to have these meetings if at all possible. Sometimes it's not possible. Sometimes judges just don't make themselves available ahead of time. But if they are open to it, then grab the opportunity if you possibly can. And just on that point, there is a really useful document which you can find on a website called the Advocates Gateway. If you look at the Advocates Toolkits, this is a website aimed at barristers. There is an Advocates Toolkit number 11, which is advice to barristers on how to prepare for interviewing a person who is deaf. And this is a really useful document, not only for you guys to read, but also to pass on to solicitors and barristers ahead of a trial or during a trial if you come up against difficulties, because it's quite a thorough document which has been which was advised upon by members of our profession. So I definitely suggest that you have a look at it and really make use of it and spread it around any barristers and judges that you come into contact with. Obviously, interpreters need to assist with the resolution of seating, sight lines, lighting, and any audio-visual needs within the court. Often the older courts that we come across, a lot of those in London, are very old and dark and are just not set up to accommodate the needs of any deaf parties. And these kind of things need to be discussed and resolved ahead of the trial beginning. This can often take up to a day, sort of the whole first day of a trial sometimes can be taken up resolving some of these things. And I've even seen the court being changed on that day. So because the particular court that was chosen was just not suitable. And so the entire trial was moved to a different court. Obviously, communication needs to be looked at, which I think I've already covered, so I think I'll move on from that. And also the interpreting team need to consider the oath. There's a special oath to be taken by the court interpreters, and you need to decide whether you would like to take an oath appropriate to your religion or whether you would like to take the non-religious oath. And also, when one interpreter is taking the oath, another interpreter needs to be interpreting the oath. So those kind of things need to be considered as well. Section H of the document looks at lawyer-client interactions, and really all of the best practices that we've been speaking about come into play during lawyer-client interactions. There's not really any difference here. One thing to say is that the interpreter should only be present with the deaf client, and this particularly is looking at deaf people who are defendants. So they should only be present with the deaf client if the client's lawyer is also present, so as to preserve the lawyer-client privilege. That privilege must not be compromised by the interpreter. The privilege sits with the lawyer, not with the interpreter. So when the lawyer is present with the interpreter, then the privilege stands. If the interpreter is present with the deaf party without the lawyer and some disclosures are made, then our position could be quite severely compromised. Section I moves on to law enforcement, again stating that all of these best practices should be taken into account with regards to law enforcement interactions. And just pointing out that some investigations may take place in settings where generalist interpreters are already engaged to interpret. So, for example, police officers might go into a school and actually conduct an interview or take a statement in a school building. There may already be interpreters in place, educational interpreters working in that environment, but it points out that those interpreters should not be the ones to be engaged for the legal interaction, and experienced legal interpreters should be brought in to conduct that or to mediate that interaction. And again, team interpreting always remains a best practice. Often we do find with law enforcement interactions, only one interpreter is engaged, but the best practice is that team interpreting is what we do. Again, deaf interpreters need to be considered. Importantly, it states that the interpretation of the caution should be video recorded as evidence of whether the rights have been understood. Now, in PACE, the Police and Criminal Evidence Act, it states that the caution must be repeated at the beginning of any interview. So usually that will be caught on camera at that point. That's often not the first time that the caution is read to the deaf party, and it's a bit of a sticky situation sometimes as to whether video recording equipment will be available when the caution is first put to the deaf party, but it's certainly something that we need to consider. And just reinforces the fact that any interactions with the potential to become evidence should ideally be video recorded. And obviously, again, as was said previously, both the source and the target language must be recorded. So the language of the deaf party and of the interpreter. So that's all the sections within the best practices document. Just to say, we've had, ASLI have had one item of feedback so far since the adoption at last year's AGM of the best practices. An interpreter got in touch to say that they were able to reliably inform a rather reluctant boss on the underlying reasons why one interpreter cannot do all the different jobs in the courtroom. They said that having one external voice was very powerful, and that they were able to back up a colleague who was facing a difficult situation. So it was really, really great to know that the best practices have been used really positively already. I've also heard of them being sort of spotted in a courtroom during a trial, and also being passed on to legal teams as well, which is really good news. ASLI would really like to hear from any of you who have made use of the guidelines. We'd really like to know your stories, your feedback, positive or negative. This is a live document. It will be reviewed. If there's anything in it that you disagree with or that you question, we really do want to hear from you. The document is due for review in 2018, and I'd really like to thank the Justice Signs project as a whole for assistance that they've given us during the editing of the document. In particular, the interpreter that you can see on your screen right now, Rob Skinner, who is research assistant on the Justice Signs project. And he's been, sorry, I'll just rewind and tell you what it is. This is a program that's a collaboration between the organisations around Europe that you can see on screen there. And they're looking at the outcomes of deaf people who have encountered the legal system in a number of different European countries. So that's an ongoing project, and they will be reporting on their findings fairly soon. We hope that in the 2018 edit of our best practice guidelines, we'll be able to make use of some of the findings that Justice Signs come across, and or they may come up with a new set of guidelines that we can then at that stage adapt to suit this country. We'll see what that looks like at the time. That's quite exciting. So interpreters are going to swap again now. And that brings us to question time. So I'm going to turn and look at Rob now and see what's coming.
Let me just get closer to the microphone. Okay, we've had a number of questions come in. Firstly, thank you very much, Cal. That was great. So I'm going to take you back. So there was a question from David Wolfenden, and this was during the section when you were talking about consecutive interpreting. There was an interesting point there that you talked about taking notes. I just need to find it. So 8.3, taking notes. Do we have any experiences of note-taking in British courts? It's really interesting that the concept of note-taking does indeed enhance the accuracy of interpreters, brackets in theory and in spoken language examples. But is there evidence that BSL to English interpretations are enhanced with note-taking strategies?
Thanks, David. That's a really good question. I do not know the answer to that right now. Off the top of my head, I have not seen or heard of note-taking being used in our courts over here. I did attempt to find someone overseas who could assist with the answer to that question, and I've not done so far, but I'm going to make a note of that and get back onto that, because I think that from Deb Russell's research, I think there is some kind of evidence to suggest that note-taking can successfully be used by sign language interpreters. However, I need to look further into that and maybe look at what training overseas interpreters have had as to how to incorporate note-taking within our practice.
Did you discuss this same question with other interpreters who fed into the development of this document? You know, did you discuss about how this is used or not used in the British courts?
We had a discussion about it, and it was acknowledged that currently we're not, as a matter of course, making use of note-taking. But it was felt that we should keep it in the document because I think it's useful for interpreters to begin to consider note-taking as a strategy. And I think we do, as a profession, need to have some further discussions about how useful it is and in what ways it has been successful or unsuccessful.
I have another question here from Steve Churchill. And he's asking, how do you persuade legal professionals who may be unaware of the interpreting process that consecutive interpreting is the most accurate, and it is therefore worth being patient and allow the interpreters extra time to interpret using consec? So how do you persuade them?
Well, I guess we all have our own strategies. I think probably in outside of court dialogue is easier than in court. I think that possibly we need to refer to the spoken language field and point to the fact that spoken language interpreters have a different default. In court, you will find that spoken language interpreters primarily will use consecutive interpreting and not simultaneous. And that's for practical reasons, obviously, for vocal overlap reasons, but it is also very much, spoken language research certainly does find that consec is the best practice for quality and accuracy as well. So I think that can be discussed with legal professionals.
It also sounds like having a best practice document like this is one solution. It seems already to be having positive impact in some areas. I mean, going back to writing notes, Gloria Ogborn just picked up on that, saying that she can't see how interpreters can write notes and suggests maybe a co-worker could do that. And there's also Byron Campbell who agrees with that suggestion. But I guess that's one for review and one for training. Yeah?
I definitely think note-taking is something we need to look at more, and I don't have all the answers relating to that.
I don't want to skip over all the questions. So I can see Lorraine Leeson's asking about how it'd be useful to have some of the references about the 22 cognitive skills that interpreters are kind of consuming as they're interpreting, and that she'd like to follow up on this.
There are references at the end of the document, so hopefully you'll find everything you need there. If you don't, then do get in touch.
Okay, so now moving up, just going to try and catch some more questions. There's been a lot of talk about training and how to get the right training, and I liked Christopher Stone's comment that it's not just about training in the classroom, it's also about attending courts and also shadowing. These are the different ways that you can develop your skills so that you can...
Very much so, and I think you know, interpreters need to take that on and just get themselves out observing court proceedings, and not only looking for proceedings that are interpreted. Just go and familiarize yourself with courts and with the sort of language that's in use and the layouts. There are different layouts in different courtrooms. Yeah, so just get yourselves out there and doing lots and lots and lots of observation. That's something that is in the document as well.
Steve Churchill has made another question. Are there lists of interpreters who specialize in different settings? That would be a useful way, he sees, of building a network, and who would be good to network with.
I believe that in the ASLI directory, you can search for interpreters who will work in different settings by setting. However, it doesn't guarantee that those interpreters are specialist interpreters in those settings. It just means that those interpreters have decided that they are okay with working in those settings. So I agree. I think it would be useful to actually have a separate location for sort of known specialists in that field. Obviously it is still a bit unfortunate that we don't have specialist certification in this country for BSL interpreters at the moment. I don't know whether that will ever come into force, but certainly if there are interpreters who are kind of known practitioners in the field, I do think it would be useful to have a place to go to find them.
Sarah Glendenning, she asks, if you're working for the barrister solicitor, how much info can you give to the court interpreters, re the communication of the deaf party? You know, any background that may be useful for your fellow colleagues?
That's a really good question, Sarah. I don't have the definitive on that. I don't know if any of the other interpreters online have a view on that. Do send a message if you do.
Okay. I remember a chat earlier on before was Byron Campbell was questioning, why do so many interpreters get it wrong when it comes to video recording interviews?
Get it wrong? What does that mean?
Why don't they position themselves or make sure that the video does capture their interpretation?
Good question. I don't have the answer.
You don't have the answer, yeah. No, it's a fair point.
There's not enough training.
Not enough training, exactly. So as the author, or not author, sorry, apologies, as the editor of this best practice document, what would you say you've learned the most, and how has it changed your interpreting style? And this is a question from me, Kal.
Can you say that again? I was just reading one of the comments.
I see.
I was a bit distracted.
So I'm aware that this process of editing and learning and scrutinizing this document so that it fits the UK or the English system, obviously you're going to learn something and you're going to kind of reflect on how you work. What would you say has been kind of the biggest revelation for you?
I think for me, the primary thing I've reflected on is the idea of making much more use of consecutive interpreting, because I think it's definitely preferable to make much more use of it, and I intend to do so. I think that it might be quite difficult to sort of get that message out there among the interpreting profession to a point where they're confident, we are confident to use it in, particularly in a courtroom environment, because I think there is, and as I think it was Deb Russell who states in her research, there is this sort of expectation that we I think she terms it keep up with the volume, where you're just expected to interpret simultaneously and go as fast as anyone is speaking, and not trip up and not have any problems. And I think often in legal environments it can be very, very difficult to ask people to stop and to interrupt appropriately. One of the elements that is raised in the document is the idea of clarifications, interpreting clarifications being made in open court that are sort of seen and heard by the jury, that could then have an effect on how much faith the jury has in the interpretation, and that can actually change the course of a trial. And these are things that I think we need to be much more mindful of, and there needs to be much more rigorous training about. I think for me it's the use of consec and working out how to incorporate that most effectively in the practice and to get other people to kind of work similarly as well.
I'm afraid I'm going to have to end it there. But I will kind of end on one note, which was from Byron Campbell, saying that we definitely need a specialist qualification. So who can take the lead? ASLI, or do we leave it to NRCPD? I think that's going to have to be a discussion that we'll have another time. But it does seem like we are moving in that direction, that interpreters are developing specialist qualifications. Actually, we've been moving in that direction for a very, very long time, and we're still moving in that direction, which is a good thing. So
yeah, and I've just seen Byron's comment about us needing to be very assertive, and I think you're absolutely right, Byron. And assertiveness, I think, probably needs to be trained as well. I think for the most part, interpreters are not assertive enough, particularly in these kind of settings. Yeah, we need to learn more about how to do that too.
Okay, well, that's it for tonight. I'd like to thank Danny Stubbs, and also thank you to Kal Newby for all her work in developing the best practice documents for ASLI.
Thank you.
And for a very interesting presentation this evening. Thank you.
Lovely. Thanks, everyone. Bye-bye.